If you must bring your refreshments with you, that is perfectly fine. We just want to make sure that we can get started on the next part of our agenda with our first official presentation. If your colleagues can hear us outside as well, we are welcoming you back into the room. Now, as you make your way back to the room, just a couple of reminders. Apart from the digital handsets or the headsets that you have on the table, we also have the interpretation booth right behind you. So interpretation is available for those who need the service. Also, a few of you have been asking about an agenda or a program. And I have good news for you. In the gift bags that you all received, there is a folder that looks very much like this, and inside you will also see your agenda. So you can feel free to follow along and stay abreast of everything that we are also abreast of. All right, so there we are. Let's make our way back in so we can resume with our first presentation of the day. Certainly hope you enjoyed your refreshments. The coffee was very welcome, so thank you very much to the Hilton staff. Once I get my thumbs up from Heather, we are going to begin. There's a thumbs up, I like to see it. So we are now going to begin with the first presentation of the symposium. It is titled, Examination of the Legislative Policy and Enforcement Landscape on Domestic Violence in the Caribbean. This presentation offers a regional overview of the Caribbean's current legal and policy frameworks addressing domestic violence. It will highlight notable progress and emerging best practices, while also identifying common gaps across the region. This session will help us set strategic directions to strengthen regional coordination, survivor protection, and legal reform in the coming years. Please join me in welcoming our presenter, Ms. Carol Watson-Williams.
Morning, everyone. So I'm going to start off with looking at the legislative policy and enforcement landscape on domestic violence in the Caribbean. I just want to start with a note which basically says that this is not a legal presentation. What I'm here to do is to bring more a gender equality lens to highlight the strengths, gaps, and the potential priority areas for future action. So I'm going to give a very broad overview of key legal and policy provisions as they exist now, and also focus on how this framework, how they've worked to protect victims. So I'm going to speak a little bit about enforcement bottlenecks and some blind spots that, mostly in enforcement, and service provision that we still have. So essentially, the presentation, as I think about it, looks at the gap between the de jure environment, the laws and the policies that we have designed and the reforms that we have made, and what we can think about as the substantive protections and lived experiences of both survivors and victims of domestic violence in the Caribbean. And this accords with the many general recommendations from CEDAW, which really forces us to think that we must, yes, have formal provisions, but substantive equality, substantive gender equality is really more about the outcomes. and I will suggest issues for consideration to fill some of the gaps that we have identified. I think of this process as a marathon. I call it the long arc reform, because we have been here before, and I don't say that cynically. I say that recognizing that we have to keep coming back, we have to keep turning up. And I think it was the IDB rep, someone spoke about the Unite to End Violence Against Women campaign, which was launched in the Caribbean 15 years ago. And in that campaign, we brought together the ministers of government, members of the judiciary, government agencies, UN reps, and civil society organizations. And the main aim was to strengthen accountability and to transform cultures to eliminate violence against women and girls. I was happy to hear across all the opening speeches this morning, there was talk about the culture, the culture, the culture, the culture, which is something that we know anchors this problem that we have. And that campaign was grounded in the global human rights frameworks, the Declaration on Human Rights, CEDAW, Rights of the Child, and of course the Belém do Pará Convention on Violence Against Women. So the core focus was, as I said, to promote state accountability and protect and fulfill women's human rights, foster a culture of peace, and so on. So the commitments made at the time was to recognize that violence against women and girls, including sexual assault, child and sex abuse, and trafficking, that these are all violations of women's human rights, and they remain a barrier to the achievement of gender equality. This morning, we spoke about the fact that this is still a critical problem. Data from 6 Caribbean countries, it's 6 now because we had Bahamas in 2022, tell us that we still have very high levels of gender-based violence, but in particular, intimate partner violence in the Caribbean. And we saw where almost 1 in 2 of women in the Caribbean have experienced some kind of intimate partner violence. And in these prevalence studies, we defined intimate partner violence in the way a lot of domestic violence legislation have now begun to define it, which is physical, sexual, emotional, and financial. So the 4 dimensions is what we looked at. And Guyana had the highest rates of intimate partner violence, and the Bahamas and Jamaica had the highest rates of non-partner sexual violence, because those surveys were not just at intimate partner violence, but they also included non-partner sexual violence. So we know it remains a critical problem. I like to say, if we think about, when we say 1 in 3, or we say 46%, or whatever the percentage is, it sounds like data. But I like to think that every time I walk in a room, there is a woman there who has had this experience. Every time I walk in a room, there's a woman there. No matter what the room is, what the occasion is, there's a woman there. And I think, you know, I sort of embed that in my consciousness around the work that we do on intimate partner violence and gender-based violence. We know that norms and cultural beliefs continue to normalize violence. I heard the Honorable Attorney General talk about his experience as a young boy and what he heard. And it is true that we still have these norms, but these norms are shifting. When we did the prevalence surveys, there was a module that looked at beliefs about gender-based violence, you know, conditions under which you think women deserve to be assaulted and so on. And really, the responses showed that there isn't this strong belief in the norm of intimate partner violence. Women, they reject that. They did not embrace that idea. But we know that across the society, we still have that belief. And two things I just want to flag here is that although it's shifting, there is still a concern about the rate at which young people hold these beliefs. So we know that we have a generational problem because young people still hold these beliefs. But the data also tells us that rates of perpetration and victimization are higher for individuals who were raised in homes where they saw their mother abused. So we know that there is an intergenerational link to, in domestic violence. And I also heard the Attorney General ask about whether there is work that talks about how it links to generalized violence. And there is work. I'm not so familiar with the work in the Caribbean, but there is definitely work that talks about how violence in the family affects perpetration in crime in general. And we often say that intimate partner violence is viewed as a private issue. And when I was going back, sitting here on my slide, I thought, but who views it that way? Because if we look at the data that we collected in the prevalence survey, women speak about their victimization. They just don't report it. So they will say that they tell their friends and family, but they haven't made the next step to what we would formally call help seeking. And help, because telling a friend or family is not defined as help seeking. I'm not going to say it's not help seeking, but it's not defined in the research as help seeking. So they tell somebody, and I always point out that by the time a woman is murdered, there were many people who knew that she was being victimized. It rarely ever just happens like that. Their interviews and the father says, yes, I told her to leave him, or yes, we were trying to do, or whatever. But women speak about their victimization. The challenge we have is moving that sharing within friends and family and those networks, so to call them informal, to reporting and accessing the remedies and the reliefs that are available in the legal system. And we know that in some countries, in the rural areas, show a much higher rate of tolerance for IPV than in others, and specifically in Belize and Guyana. Sometimes as policy people, we like to look at the numbers. I heard the CDB say, I wrote it down and I forget, but to the effect that the budget is a powerful instrument, right? So we like to look at the numbers. And the work that we have in the Caribbean so far on the economic cost of violence tells us that it cost a country like Jamaica about 6.5% of the country's GDP. And that estimate includes the cost to survivors, to the families, to the government to respond to GBV, to businesses because of lost hours and productivity, and basically to the country as a whole. So this is the estimate. And this is very important for us to flag because globally, the economic cost of violence is estimated to be about 2% of the global GDP. So here we're already running 3 times more, 3+ times more. So it is of grave cost to us. So I say all of that not to pretend that we haven't made progress. We have made quite a bit of progress in the region since the Unite Caribbean initiative 15 years ago. Since then, we have had several states make reforms to their domestic violence act. I think, I feel that Barbados may have led that with the reforms that they made in 2016. And many of these reforms were influenced by the CARICOM OECS models that were designed, I think, is it UN Women and other partners in the Caribbean. But we know that both the pace of the reform and the pace of implementation has varied because the capacity varies across countries. But where you've had reforms, they have been very strong, expanding standing, that is, who can apply for protection orders, widening that scope, creating higher breaches for for violation of protection orders. So, for example, in Jamaica, it moved from, I think, $10,000 to $1 million Jamaican dollars for a violation of protection orders under the 2024 amendment of the Domestic Violence Act. And of course, they've introduced things like ex parte and emergency protection orders. And a lot of the legislation have outlined very clear duties and powers of the police in the legislation. And that, I'm sure, is going to get spoken about in the session to come. But those have been very important amendments. So we have Barbados had their amendments in 2016, Trinidad followed in 2020, St. Lucia in 2024. The Bahamas have a new law, the Protection Against Violence Act, which is they promulgated in 2023. And Guyana has taken a sort of innovative approach, if you want, 10 minutes, I'm told, a sort of innovative approach with the Family Violence Act. And of course, Jamaica had their Domestic Violence Act. So just to highlight one or two of the critical things. So St. Lucia has a very comprehensive definition, so does Barbados, of domestic violence, and it includes physical, psychological, economic, and cyber-based abuse. I think the difference is the cyber-based abuse because a lot of the other countries don't have that. Guyana and Trinidad provide broad coverage for multiple forms of coercive and intimate partner violence. And we have expanded definitions in Jamaica, and of course I said about the Violence Prevention Act. We have seen in the region where we now have inclusive protection for diverse relationships, so Guyana, St. Lucia, and Trinidad extend protection to cohabiting, dating, visiting, Jamaica has visiting, and same-sex partners, that's the difference. And this represents a shift in the human rights-based and non-discriminative frameworks that we have in the region. We also have more explicit and extensive mandates for police procedures. So we now have that they must respond to reports. In some instances, they must investigate. They must establish recording and reporting mandates. And in some cases, to provide reports to a domestic violence register in the case of Belize. I think Trinidad may have that provision as well. And doing other things, risk assessment, providing assistance to secure medical attention. And these new versions of our legislation focus a lot on the core ethical principles in domestic violence case management. Do no harm. Don't re-traumatize victims. The whole issue of confidentiality, we don't need to know that so-and-so came to the police and reported this. Informed consent, particularly when there's referrals for services being made. I'm going to skip the Barbados amendment because the real purpose I had this there was about the definition, but the Attorney General read that definition in his presentation. And I want to look a little bit at the scope of the Guyana Family Violence Act. So it covers a whole range of relationships in the family. And of course, as I said, it looks at the economic abuse, coercive control, and so on. And it integrates some procedures that were part of the model legislation program, where in-camera hearings, alternatives to direct cross-examination, particularly for children, video link testimony, and and the whole matter of bail considers some important issues such as the victim or the child's safety. So those have been very important developments. We've also made progress in our policy landscape. So several countries have national action plans by different names and integrated in different ways. Some have these activities integrated under their national policy for gender equality. Some have standalone plans and strategies to deal with the whole issue of domestic violence. And it's emerging in some countries. So like Turks and Caicos, the BVI and Haiti, they have expressed intentions to move in this direction. We've also seen development of several referral pathways. And in the case of Bahamas, their act sets up I'm going to call it a gender-based violence commission. It isn't fully operationalized, but it is made, provision is made for it. There are specialized courts. We've spoken a bit about that. Antigua has what is considered a model specialized courts on sexual offenses. Other countries have different approaches. So in Jamaica, for example, a particular day is the sexual offenses day in the parish court system, and so on and so forth. And there have been training in good practices and some improvements in data collection arrangements. We all know about the prevalence surveys, but there have been other data collection arrangements that have been improved with the protocols and guidelines. So Trinidad has a very interesting system where they have an intimate partner violence and sexual health care form, and they have guidance on case management around intimate partner violence in their health system. And we've also seen where there's been training of judicial officers and so on. But of course, I'm going to get to the persistent gaps. So even with all of these reforms, we still have some uneven legal protection, because not all laws extend to dating or same-sex relationships, so you have constraints in those areas. Even though we know we have some inclusive frameworks in Guyana, St. Lucia, and Trinidad, but they are exceptions across the region. So we're hoping people will move towards that. And one of the main gap is the issue of technology-facilitated violence. Other countries, so St. Lucia deals with it under their domestic violence law, but other countries, such as Jamaica, have cybersecurity acts that cover the issue. Whether it covers the issue what is the word I want? Adequately, it's another thing. And then the marital rape laws, it's not, we still have exceptions for marital rape in the region, which of course, we don't need to say. So some of the things we are concerned about is in the implementation gap, because we know that where you have gaps in implementation, it can render laws and policies ineffective and undermine the realization of substantive protections for victims and survivors. I'm going to spend just a second, Heather, to say something about this particular point, because I want to say here that the part of what we have to consider is to look at how the processes that are used to develop these laws and policies. So there is a lot of consultation, and there is inclusion in many respects, but somehow when we come to the final policy or legal document, we still have these gaps. So we have to look again at how the policy development processes that we're using and how they can be reinforcing the gaps that we see on the ground over time. So a big gap is that the services remain uneven and underfunded. The budget is a powerful thing, and services to improve access to justice aren't as robust as we would want. So we have some countries most countries do not provide legal aid for domestic violence victims. and where that support is available, it's usually through and some NGO or civil society organization. And it's very, very common for victims not to know the remedies that are available or how to access these remedies. And when you say that, people say, but how is it that they don't know? When you speak to women who are survivors, they talk about the fact that they did not know where to turn, and it was only when they went to this organization or that organization and they were directed, that is how they were able to get a grip of the situation and to protect themselves. So these services are very important, and funding for them key to having women protected substantially. And we have the problem, the perennial problem of poor coordination of services, despite the existence of these referral pathways and so on. This problem of poor enforcement of protection orders in particular is a very, very critical problem. And we have tried to deal with it through training, through capacity development in the security forces and so on. But we still see the problem right across the board, from Bahamas to Trinidad to Jamaica to right across the board. And reports of implicit bias in outcomes of cases. I'm glad tomorrow there's going to be a robust discussion on Samantha's case, as I call it, the Todd Lampkin case. Because we need to see how some of the biases are manifested in systems, that women have to encounter. I only have 4 more slides. And so there's a very interesting report that was done for Jamaica that looked at the difference between the justice standards and the lived experiences of survivors of gender-based violence. And these are some of the results. So it talked about implicit bias and delays in securing remedies and the difficulties women have accessing services. I really want to just touch just a little bit on the shelter services. In some jurisdictions, before a woman can access the shelter, she has to prove that she has filed for a protection order. Think about that. What that means to that woman's life if she is trying to secure her life, right? And there is, when you talk to the people who put the systems in place, there's good reason for it. But we have to consider how we're going to do those things. And the data problem is with us, and although we have several promising initiatives, so in Trinidad, they have a digital case management system, which is a good practice, and it provides a model for integrated survivor-centered case management. And that is a practice that we would want to see rolled out or adopted in other parts of the Caribbean, provided that it is actually enforced and working. So, we want to make sure that we have the case management system, but it's actually doing what it is supposed to do. Then there have been some regional guidelines done by UN Women on the use of administrative data to support domestic violence programming, and there's been little take-up on this work, on the guidelines. I've done work in Jamaica on it, and in Grenada, and in both instances, there's a general acknowledgement of the value, but the hesitancy is, well, what do we do next? So, going forward, I wouldn't call it hand-holding, but certainly capacity building and making sure that these things become real and active and not just there. I think for consideration, we want to look at things, I call it wraparound training. So it's training for everybody, is how I see it. It's training for law enforcement, it's training for judicial officers, it's training for healthcare workers, it's training for the service providers in the NGOs. Sometimes we tend to treat NGOs like a special category, but they have their bias problems too, and we have to address those. So it's wraparound training, because if we don't, we're going to have a sort of inconsistency in the quality of care. I just want to make the point that this training really helps to embed the legislative policy and enforcement considerations in the heart of the apparatus, and that is what is going to make them effective. There can be no success without full knowledge and understanding of the why. So it is the complexity of domestic violence, the fact that sometimes women report and then they withdraw the report, they go back and then they leave. And you know, we can use these things to judge a victim, to make an assessment of her seriousness. But it is a very traumatic and complex process. And if we build victim experiences in our policy and legal development processes, that will help us to understand you know, the different iterations, the different things victims go through. So that is the why. Just 2 more slides. The other thing that, and I see that on the agenda, we're going to get to that, looking at perpetration and perpetrators. So there has been some work in many countries. I have these here, but in other countries as well. But there have been piecemeal work. So you haven't had the consistency and the focus looking at perpetrators and perpetration. And one of the concerns that I have is that the existing attempts sometimes don't address the entrenched and problematic norms which drive domestic violence. Rather, some play into these norms. So they, you know, speak to men, oh, you have to be the protector, remember that she's depending on you. They play into these norms of the power imbalance between men and women, even as they're trying to address perpetration. I get it, but we have to flag it and see how we can help organizations who are trying to help. They're not trying to do harm, they're trying to help. But see how we can help them to have a different understanding of, you know, how some kinds of messaging are not very helpful in the end. And we've seen some programs on the family courts, but a lot of these programs have been donor funded. And one of the persistent problems we all know we have in the region is that when the donor funding goes, the activity goes, and so we lose momentum that way. In a way, it's better to have had it than never to have had it, because every little thing builds together to change the environment, is my view. And then, of course, there's the matter of data. So we know that data helps to map connections and assess risks. One of the things that I will always speak about, because somehow it gets overlooked, is this whole matter of early cohabitation or child marriage and the rate of intimate partner violence. Girls who begin living with a partner before they're 18 years old have far higher rates of victimization, intimate partner victimization, than girls who started in these these living arrangements when they're older. It's a very important point. And we have a culture in the Caribbean where there is a lot of silence around young girls living with older men. And because it is ignored, those girls don't have the level of protection that they're entitled to. One of the things that we've done some prevalence surveys, they're very expensive. We know they're very expensive. So it's important, I think, that we consider more cost-effective ways of collecting prevalence data consistently. And there are other jurisdictions that do telephone surveys, they do online surveys. They're not simple, but I think we can come up with some model in the Caribbean to allow us to collect this data more consistently and more cost-effectively. So I think last slide, really need to focus on things that will shift the needle in the lives of the victims and survivors. That is the responsibility that we have. So reforms in the laws and development of and of policies, those have been extremely important in expanding protection and inclusiveness and in streamlining systems and setting standards. And although it's not perfect, as we all know, so the next frontier must focus consistently on effective prevention programs and building on-the-ground capacity to support victims and survivors of domestic violence, because we do need to close what we call the practice gap. And if we're able to do that, we can move into a new era, which I think is something that this symposium is all about and wants to facilitate. So thank you very much.
Thank you so much, Ms. Carol Watson-Williams. Next, we will continue with our first panel discussion, which brings together attorneys general from across the Caribbean to reflect on existing legislative frameworks on domestic violence and the gaps that continue to hinder effective survivor protection. By now, many of you would have been introduced to the Hoover app, and you can submit your questions throughout the session for the Q&A tool during the discussion. Right now, I am going to ask Darren Carter of CDB just to join me and give us a very, very quick and easy demonstration on how to use the app, particularly the Q&A tool, for those of you who wish to use that during the panel discussion. Darren?
Sure. Good morning, ladies and gentlemen. Sorry. Yes, good morning, ladies and gentlemen. Just a quick overview on how to use the Q&A tool. So once you download the app, you can either visit Hoover via your desktop or mobile app. On the desktop, when you visit the app, and you'll be greeted by the landing page with a brief summary of the event. If you scroll to the Resources tab, it's the last tab on the bottom on the left-hand side of the page. Click on Resources. Session Q&A is the first tab. You can submit your questions there for each session. On the app, similar landing page. On the Home tab, if you scroll to the very bottom underneath Additional Resources, there is a tab called Session Q&A. Again, same functionality. You can submit your Q&A, your questions there. Thank you.
Thank you so much, Darren. At this time, I'd ask you to join me in welcoming our distinguished panelists. Honorable Dale Marshall, Attorney General and Minister of Legal Affairs, Barbados. Honorable Garth Lucien Wilkin, Attorney General and Minister of Justice and Legal Affairs, St. Kitts and Nevis. Honorable Mohabir Anil Nandlall, Attorney General and Minister of Legal Affairs, Cooperative, Republic of Guyana. And I believe she is here, Honorable Rhondalee Braithwaite-Knowles. No, she's not joining us today, right? Okay, so we are going to invite Ms. Roberta Clarke. Roberta Clarke is Commissioner of the Inter-American Commission on Human Rights, and she will be moderating this important discussion. Ladies and gentlemen, please a round of applause for our panelists and moderator.
Yes, thank you very much. Thank you, Gaynell. A good moderator has to have a timepiece or we run over time. But I want to first of all thank the organizers of this important meeting for the invitation to me to for support and to facilitate this important panel. I think it is, as our previous presenters spoke about the progress, and I think we always must start with acknowledging progress, or we may become cynical and depressed. My first memory of domestic violence was Dale. I was Attorney General of Barbados. I was a little girl in the Pine, driving in a car on Sunday and seeing a man beat a woman. It was around maybe 1 o'clock in the afternoon, broad daylight, in an open area with a 2x4, you know, a big piece of wood. And he was doing that, neighbors were around, and it was just going on. My father stopped the car and he intervened, and it was a powerful example for me of bystander intervention, but also it stayed with me because it was so happening so normally in that community. I think all the years later, a lot has changed, and we do have a cultural shift, even though we are not satisfied with the pace of the cultural shift or the shift in institutional responses. And I would like to also acknowledge as we start off that women's organizations being advocates for policy reform as well as providers of services, in particular shelters, were very much championing the work that has happened here to do two things. One, guarantee better victim safety, and secondly, also calling for perpetrator accountability and holding the state to account for addressing what is essentially a manifestation of unequal power relations between women and men. Tomorrow we'll hear more about the Todd Lampkin case, but it is such a powerful statement of the duty of the state to act when it knows or it ought to know that someone is in harm's way or being a victim. And we'll hear a lot more tomorrow from the lawyers, but also from Ms. Lampkin herself. So we've had, you know, I think what I call 3 periods of reform. The first act in this region came from the Bahamas, and then Barbados was second. We had a second set of reforms in early 2000s, and now we have, for some countries, on their third phase of reform, in particular Trinidad and Tobago. This, and of course Guyana had a big reform, I think its second major reform of the domestic violence framework, expanded to speak to family violence. This panel this morning, we have Attorneys General from Barbados, St. Kitts and Nevis, and from the Cooperative Republic of Guyana. And we've asked the Attorneys General to reflect with us, each for about 15 minutes, on 4 questions. Firstly, what has been the major legislative reform in their countries in recent years? And we want to ask them not only to tell us what the reforms have been, but are they working? Are these reforms working? And if they are, what is the evidence of that? If they're not working, what, in the view of the Attorneys General, would be some of the reasons for the deficits, if any? And then we want to ask them whether or not the culture of responsiveness has changed, particularly in the context of the criminal justice system. Has the culture of response of police changed appreciably? Has the culture of response of the courts changed to reduce delay and to have efficacious response to applications for protection orders? And of course, has there been a degree of coordination between the justice system and social services to cover protection for those particularly in harm's way, but also to intervene with perpetrators? And then finally, the 4th question that the Attorneys General will be speaking to each other about and with us, what in their views are the further reforms that may be needed? And Attorney General, these reforms don't have to just be in law, they could be in practice. What kinds of practice reforms would be needed to make the implementation of these acts more consistent and a better guarantor for accountability as well as safety? So with that, I would like to introduce our first speaker, the Honorable Dale Marshall, who's Attorney General of Barbados. He needs no introduction from me. He spoke to you all this morning, except to say that he is an attorney for at least 35 years, I understand, Attorney General. I should know because we were in the same year together at law school. And he also currently leads the country's anti-money laundering network and is leading the criminal justice reform processes, which I think are connected to this issue as well. And so I will ask Attorney General, you will have 15 minutes, and then we move on And I will then introduce the other Attorneys General as before they speak. Over to you.
Thanks very much, Roberta, and very kind of you to reflect on the fact that we were contemporaries. Some of us have aged a little better than others, and for that I compliment you. Colleagues, friends, when we passed our domestic violence legislation in 1992, it was truly seminal. We had a situation where there were no legislative arrangements that were clear. You had to use whatever mechanisms you could find in order to be able to offer an individual protection. And those who had resources could approach the High Court and get an injunction. But the average person who didn't have those resources, and we know we're talking about the average woman in the country, had to find other means of addressing it. And therefore, in 1992, when we enacted that legislation, it was seen as being a total transformation of the environment for the protection of vulnerable women in domestic relationships. And it was certainly seized upon. There were a lot of applications made over the years to the Magistrates Court. And it was, I think that early legislation worked very well for Barbados. But of course, after almost 30 years, you found that, notwithstanding that some attitudes had changed, it was necessary to revisit that legislation and try to see what are the additional powers that needed to be in the hands of the magistrate, whether there were other issues that had to be addressed. And in 2016, in fact, I was in Parliament at the time, and I well remember the debate of the legislation. In fact, the amendment legislation was done at a time when I was in opposition. And we certainly supported the legislation, but we felt that notwithstanding that the amendments were timely, that there were other things that needed to be considered at that point in time, same-sex violence and so on. But the Parliament of that day did not feel at liberty, I suppose you could say, to go that far. Certainly in opposition, we had a view that we needed to look at the entire panoply of domestic arrangements. The important features of those legislative changes at that time, I think one of the key ones had to do with the ability of a police officer to issue an emergency protection order. Generally, where a person applies for protection order, you get to the magistrate as soon as possible. But often, on a long weekend, it is difficult to get to a magistrate. The magistrate may have left for the day, and those kinds of things. And it was obvious to us that it would be foolhardy to rely on the efficacy of the magistracy to be able to address urgent cases. And therefore, the ability for a police officer to issue an emergency protection order and immediately help to alleviate a dangerous situation was a very valuable tool. And I can tell you that that has happened on numerous occasions. It's not something that's readily issued by the police service, but certainly my discussions with the magistracy and others have allowed me to be satisfied that it is a tool that is used, not on a day-to-day basis, but certainly when the occasion arises for it to be used. The police have not been shy about using it, and that is certainly an advantageous thing. There were some other reforms that we made, and it had to do with expanding. They had to do with expanding the ability of the court to make additional orders, and some of them are really quite important. The ability of the court in a domestic violence situation to order compensation for pecuniary loss. These things often result in the need to seek medical attention. As a result of the injury suffered, you may be off from work, and we therefore felt it was important to allow a magistrate And let me just make it clear, all of our domestic violence matters are heard by the magistracy, simply because it is important that people have access to justice in the community. I think we have a number of magistrates' courts scattered around Barbados, and therefore it is easier for a woman in Bathsheba to get to the Horse Hill Court to see a magistrate and have her matters addressed. And equally, a magistrate in a particular district will have an idea of the individuals that they're seeing on a regular basis and be able to dispense justice in that kind of way. And therefore, the ability to order maintenance, the ability to order compensation for pecuniary loss, those kinds of things. But then we went even further. Some of these individuals have firearm licenses, and it was therefore important for the magistrate to be able to make an order that firearms, ammunition, and so on be seized. That did not exist in the earlier legislation, and therefore that was an important thing. We have increased the obligations on the police service. In fact, it is almost, I guess, prescient, because when you look at the Totlamkin decision tomorrow, you will see that there were a significant number of failings on the part that were perceived to have been on the part of the police service. We have introduced in 2016 a number of new obligations and duties on the part of the police service, so that they have, the statute stipulates that they have a duty to respond to every complaint, every single complaint. They have a duty to complete a report on the complaint. They have a duty to give both the complainant and the other party a copy of the report. They have an obligation to render assistance to the victim, inform the victim of their rights, as I mentioned, seizing ammunition, things of that sort. But then there's also an obligation created on the police commissioner to keep a register of domestic violence reports, which is important, and we are able to therefore track what is happening in terms of domestic violence in Barbados, because of that duty to collect and to record the information. So we're satisfied that the kinds of initiatives that we've taken have been very supportive, have been very helpful. But of course, there are other things. The other challenges, I've mentioned, of course, the fact that we don't have a statutory recognition of same-sex, and therefore that has not been included. That has been a very emotive public issue in Barbados, I'll admit. But I think that a number of things are taking place which will force us really to take the legislation in that direction going forward. In terms of our other issues which are not necessarily going to be statute-based, the number of support services that are available. We have a limited set of accommodation that is available to women and their children who are victims of domestic violence. But as I said, it is limited. And in a small country like Barbados, the truth is everybody knows where it is. It's not going to be in any remote location. So you've had instances where perpetrators of domestic violence have shown up at the shelter to intimidate and so on. But those are some practical difficulties that we have to face. Our ability to offer accommodation that is secure, that is safe, so that the individual can try to reestablish some kind of reasonable life until such time as more permanent arrangements can be made. Another practical issue is the fact that victims of domestic violence don't have access to legal aid. And certainly from my discussions with the magistracy, this is a key initiative that we need to implement. The burden on the magistrate where an individual is not protected is not represented is greater, because that magistrate now has to take the time to elicit evidence and still be the arbiter. And that, of course, puts the magistrate in a difficult position, because you can't elicit evidence and then try to make a reasonable determination following legal legal good practices and make a decision on it. You are, in essence, trying the very case that you are presenting to yourself. Our legal aid arrangements do not currently include this, and therefore it would be advantageous for us to extend our legislation so as to allow for a victim of domestic violence to have legal aid. And then, of course, you get, because the individual who is the perpetrator often has notice, the court may grant an adjournment, not often, but it may, and that person shows up with a lawyer, so you're not operating on even terms. The victim tends to be unrepresented. They tend to be giving evidence from a very emotional and pained place, and therefore it is not necessarily the fair system for them to have to stand up against a lawyer that is brought in by the other side. So that's another area in which I think we need to make some reform. And then, of course, the one that I think is obvious, will have to be training for judicial officers. In our environment in Barbados, while we have a permanent magistracy, individuals will naturally go on holiday, individuals may be promoted out to work in other departments, and therefore we have to have the issue of constant training available for members of the magistracy so that they do not approach domestic violence matters from the point of view of a legislative script. We have the benefit of one of our more senior magistrates here, but he's been hearing these matters for many, many years. But a newer magistrate, and I think we're about to recruit another 3 or so individuals to the magistracy, we have to make sure that they are trained so that they're able to respond to these issues in a practical way. So, but I don't think I want to go any further at this point. I'll wait on questions, but I think I've looked at one gap, and that has to do with same-sex. I've looked at what our reforms are, and as to whether they work, perhaps I haven't said that. I think that our reforms have largely been beneficial, and we can obviously do more, but I think those additional things are going to have to be in terms of shelters, in terms of legal aid, things of that sort.
Thank you very much, Attorney General. And I have some questions for you, but we'll do all presentations, and then I think my questions may be anticipated or anticipatory of questions from the room. I want to now introduce the Honorable Garth Lucien Wilkin, who's Attorney General and Minister of Justice and Legal Affairs from St. Kitts and Nevis. The Attorney General, also, I think you have an engineering background. It may help you to help us think in structured ways about improvements. Before his appointment as Attorney General, he practiced as a commercial litigation specialist, and he also served as president of the St. Kitts and Nevis Bar Association. Attorney General, the floor is open to you and your intervention.
Thank you, Madam Moderator. Good morning to all, especially my colleague AGs from Guyana and Barbados. But before I start, I think we all need to send our prayers and thoughts to our brothers and sisters in Jamaica, Haiti, the Dominican Republic, Cuba, Turks and Caicos, and the Bahamas as they go through and are likely impacted by Hurricane Melissa over the next couple of days. Growing up in the hurricane belt in St. Kitts and Nevis, my grandmother always used to say, June too soon, October all over. But clearly that has changed, because we are now in late October and we are seeing a hurricane that's impacting our people. So if you are for solutions to domestic violence problems, you also have to be for solutions for climate change, because even though it's not our cause, we are the persons on the front line. But in relation to the first question, Madam Moderator, what are the recent reforms in St. Kitts and Nevis? We had an OECS model bill that we passed into legislation in 2014. So I can fairly confidently say that we have modern legislation. And we then brought it into operation. I'm not so sure why the delay was there. I was not there at the time, in 2019. And when we took office in August 2022, one of our first orders of business was to amend the legislation. And actually, in our first substantive parliamentary sit-in in November 2022, we passed an amendment to that legislation. So that legislation is robust. Many of the things that AG has said already in relation to the particular aspects of the Bayesian legislation, which was the 2016 legislation, we have in ours. But we found when we came in that there were some gaps that were identified by the Ministry of Gender Affairs, so we closed those gaps. The biggest of that was in relation to access to justice. The 2014 legislation required victims, survivors, to go to the High Court to seek protection orders. And in St. Kitts and Nevis, going to the High Court is costing you at least $2,500 US to $4,000 US dollars. And we felt that it was not getting to the persons who needed it the most, to the persons who are vulnerable financially. So what we did was we amended the legislation in 2022 to allow for applications to be made to the Magistrates Court. And all it takes to bring an application to the Magistrates Court is $2.50 US, $6 EC. And you can have your matter heard and you can get an order. So those amendments are very important. But from a macro level, I see what we're doing today as part of the bigger picture. The heads decided in 2023 that we're going to treat crime and violence as a public health issue. Naturally, domestic violence falls within that realm. And I don't want persons in the room to think that we're just in another talk shop where persons come and they hear conversations and nothing happens. St. Kitts and Nevis is a testament that that is not true. When we came here in this very room, actually 2 years ago, when we settled on the Needham's Point Declaration on criminal justice reform, and subsequent to that, the heads determined, just before that, the heads determined that we're going to treat crime and violence from a public health perspective. We have seen a reduction in homicides of 73%, just by implementing innovative methods that were discussed at that very meeting. So I see no reason why what we're discussing today cannot have the same impact in relation to domestic violence. All you need a guidebook, you need data, and you need political will. And those are the things that have contributed to our success in relation to homicides. I'm hoping that today is a start for us to get that same result in relation to domestic violence. But we have robust legislation. We have access to justice now, where persons can go to the court, or police officers, or members of the Office of Gender Affairs can actually apply on behalf of victims to the court. So the individual does not have to go to the court themselves, of course, once they have consent. So that is not an issue for us. And I think we have because of our strong legislation, we're seeing results. I inquired with the courts to see how many applications were being filed in the Magistrates Court. I was happy to hear that in 2023, which was in the first year, was 20. 2024, it was 20 again. And in this year thus far, there have been 35. So people have been accessing the courts. That means it's working. But what I think is not working, and what worked for us, and maybe that's the reason why I brought up the issue of homicides. In order for us to create the pathway to resolve and reduce our homicides, we had to have a report with the data. USAID prepared a report on gang culture in St. Kitts and Nevis. And that was what catapulted our response with policy and legislation, in addition to the Needham's Point. So if we are to take domestic violence more seriously, I speak for my country alone, we need some sort of data upon which to develop new policies. Because legislation by itself is not enough. You need to have a plan. You need to have all of the stakeholders involved. You need to have everybody on the same page. And that is the way you get that. You find out from the data where the issues are. Are they in particular communities? What is the income level of the persons who are victims of domestic violence? Is there correlation with any other sort of employment? Is it among construction workers, construction worker males? Is it typically amongst blue collar persons, white collar professionals? We need that type of data to then develop responses that we can see results. So when you asked earlier about, is it working? That's a complex question. In my mind, if you are looking at it from the legislative reform perspective, for St. Kitts and Nevis, it is working because persons have access to justice. And there are no high hurdles for persons to be able to go to the courts and get protective orders or go before the Special Victims Unit and seek assistance. But the bigger issue, is it working, is more of reduction in the numbers of cases. And we have not seen a reduction in number of cases over the last 6 years. What we saw was a huge spike, I think around 350% during COVID, when persons were cooped up in their homes and persons had economic challenges and so forth. We then saw a leveling off after that. Around in our country of 50,000 people, we're getting around 80 to 90 reports of domestic violence per year. 80 to 90 per year, and that is still too much. We're seeing the actual incidents, and those are the ones that are reported to the police. That doesn't necessarily mean that those are the numbers. But if we want to see true success, we want to see a reduction in those numbers. How you get there is that persons have to know that they have access to be able to seek justice. It's affordable. They have to understand that they should not accept, as A.G. Marshall said this morning, that is something commonly said in St. Kitts and Nevis. I know he's from St. George, but that could have equally been in St. Paul's in St. Kitts and Nevis, where persons say, if your man does not hit you, he doesn't love you. And that is unfortunately a relic of our Caribbean history. And if we don't change mentalities, we're not going to see any results. So we have to educate our people. We have to advocate against domestic violence. We have to show that there are comparable punishments. We have to increase penalties to discourage persons. We also have to make sure that we have mediation available. We have to have reintegration processes when actual somebody who commits domestic violence is incarcerated and then they are returned into the community or into the family. There needs to be some sort of reintegration mechanisms. But one of the successes we have seen is in relation to the coordination. We in 2017, in collaboration with PAHO and UNIFEM, I believe it is, there was a protocol that was set up in St. Kitts and Nevis, which set out the framework under which the Special Victims Unit of the police force, the Department of Gender Affairs, the judiciary, and NGOs, there's a coordinated effort, everybody playing their role. Of course, the police being the first responders, the gender affairs being involved in mediation and part of the process, the courts facilitating quicker hearing of applications for protection orders, and then the NGOs volunteering places for victims and survivors to go whilst their matters are being resolved. So we have that strong coordination effort, and as I said, if we partnerships with IDB, CDB, if we can get reports, if we can get protocols that are better, if we can get training, we will always see better results. Let me see. The other questions are, yes, how things can be strengthened. Okay, and very important, I want to repeat this 3 times. Data, data, data. If anyone in the room knows of a way that we can get a report prepared in St. Kitts and Nevis, please find me before the end of tomorrow, because as I said, that is the only way that we can find solutions. My Prime Minister is a medical doctor, and he's very much into science. I'm an engineer converted into lawyer, and I very much believe in math and data and doing things in a structured way. And that is really the foundation. If we do not have the data, we're not going to get to where we want to be, which is to reduce the incidence of domestic violence and be able to help, in particular, the women who form the majority of the persons who are victims of domestic violence. In St. Kitts and Nevis, 80% of the victims, victims/survivors, I know survivors is the better language to use, are women. We don't have the issue that A.G. Marshall has. Our definition of persons who can get orders covers same-sex relationships. It doesn't say so explicitly, but because of our definitions, it allows for anyone, any family member, or any person in a relationship, whether living or visiting, can move the court to get an order. So we don't have that issue. And I have not seen any legislative gaps that have been identified by the Gender Affairs team, other than the fact that the police have requested that we have specific domestic violence offenses. And AG Marshall, I don't know if you all have that in your 2016, but we certainly don't. We have penalties for offending the act, but we don't have actual domestic violence specific offenses. They still have to fall under the different categories of offenses in the toolkit, and the police have asked for specific offenses in our legislation. So that's going to be the next step of our reform, unless and until I hear something at this meeting which sounds good and sounds important to do, and then I'll bring it to the table, and then we could move forward. But I want to end where I began. Do not treat meetings like this as talk shops. Treat them as catapults. So when you go back to our countries, we can change the dynamic and we can actually really make a difference.
Thank you very much, Attorney General. The last thing you said triggered a thought for me, where the police are asking for some guidance on specific criminal law around domestic violence offenses. Indeed, that's been a deficit all across the Caribbean, that police use the domestic violence protection orders as a proxy for action. So they would tell the victims, well, go to the magistrate's court and you can get your order there, even though what has been threatened or has been done amounts to a criminal offense under Offenses Against a Person legislation in any event. We had an egregious case in Trinidad and Tobago where the woman went to the police station and told the police that he threatened to kill me, put a knife to my neck. He threatened to kill me. And the police said, well, you need to go to the hospital and get a medical report. I don't know why, but that was the guy. They sent her off on her own rather than going to arrest him for, attempted murder. They didn't, and then he went to her house. He killed her. He killed the landlord who came to see what was happening. He killed her daughter, and he killed her daughter's friend who was visiting. This is in the last 10 years. So the idea that police must be mandated. And maybe that's one of the questions we want to ask the attorneys general here. What do we make of the idea of mandatory arrest, which can give a cool off period, but in none of the legislation is there provision for mandatory arrest where a criminal offense has happened. But I think all of these are maybe talking points for later. I would now like to introduce our Attorney General from Guyana to make his presentation, the Honorable Mohabir Anil Nandlall, who is the Attorney General now, but you've been a Member of Parliament, Attorney General, since 2006, I see, and this is your second round of being Attorney General. Of course, before being Attorney General, you also were involved in your own private practice and in landmark constitutional and public law cases, and so I think this idea of what is the state obligation must be something that you've thought a lot about in the context of domestic violence. I would like you to make your presentation. You, like your colleagues, have 15 minutes, and then we'll have a dialogue with the audience and amongst the three of you. Over to you, Attorney General.
Thank you very much, Madam Moderator. And I want to thank the organizers of this event and also to thank them for affording me the opportunity to participate. Domestic violence is an extraordinarily complex social problem in the Caribbean. And I know that I'm to speak on legislation, but long before we get to legislation, there are some issues that we have to address if we are serious about advancing a comprehensive solution. And it's to understand the nature of our society, its historical evolution. Many persons much more qualified than I am, and who have studied this phenomenon, have concluded that we are a violent society. Our societies emerge from the worst form of servitude to have visited human history, slavery, followed by a brutal system of indentureship. And inherent in those systems were systematic violence of the worst kind. So we are a product of a very violent history. And that has become part of the inalienable culture. Our way of life has in it, whether we want to accept it or not, a component of violence that have followed us by generations. A lot of things that we in the Caribbean accept as norm in our everyday life, in other society, it would be classified as violence. We all grew up in the same society that taught us that the rod had to be used to discipline our children, and we accepted that as the norm for decades. We grew up in a society where we were told that death must be met by death. So now in 2025, we have a population in the Caribbean that clings to the retention of the death penalty. We have a society in which it is or was a norm for a man to beat a woman. That was part of the society. That was part of the norm. Today, if a woman is accused of adultery, today, in any of the Caribbean society, you would have a large percentage of the ordinary men and women of that society who would share the view that a man should beat her if the allegation is correct. So you're dealing with that type of situation. And the fact that Barbados led the legislative revolution on domestic violence, but in 1992, 3 decades after independence, is an indictment on the Caribbean societies. Because it's only in 1992, 3 decades after we became independent, that our parliaments saw it necessary to make a specific attempt to outlaw this heinous social nightmare that has beleaguered our society for decades. So that is what we are dealing with. Long before it reaches the invocation and application of the legislation, how do you get the ordinary woman in St. George's, in Buxton, Guyana, in St. Peter, St. Vincent, to even go to the police when the violence is meted out? How do you get that? That realization, that social activism, because by and large they accept many forms of violence, the psychological violence that we have outlawed, the emotional violence, the financial violence, all of that in many, many households throughout the Caribbean are still considered as normal. They don't even know that that is domestic violence. They don't even know. Their understanding of domestic violence and a belated understanding of it is physical contact. So we have all sorts of wide and embracing definitions in the legislation, but those whom the legislation are intended to protect don't even know that the violence is being committed against them. So how would they even know to use it? I don't have enough time to take this where I want to take it, but I think that I've given you a brief overview of the enormity of the task that we have if we want to tackle domestic violence at a policy level and at a national level throughout the Caribbean. We have a lot of education, public awareness, a lot of work in the communities, on the ground, in the churches, in the mosques, in the mandirs, at the PTA meetings, at every conceivable important social forum in our communities. We have to talk this talk to bring awareness and education to it. So that's the first point I want to make before I get to the legislation. So, legislatively, and you saw Guyana there being one of the countries with the highest incidence of interpersonal violence. So, I hate to say it, but I seem to be speaking from a position of strength and authority. In 1996, we enacted our first expression of domestic violence law in Guyana, and it was a major accomplishment. We had our first head of state at the time, Comrade President Janet Jagan, who assented to the bill, and it was a momentous occasion because it was the first time we were introducing this type of legislation. It was completely new, and Guyana is a typical society of that which I just described. So when this legislation hit the rack, for want of a better word, it was revolutionary. I had conversations with senior lawyers, senior criminal lawyers, who disagreed with this legislation. They couldn't fathom a magistrate ordering the owner of a house who owns it by title to be out of the house. That was unheard of. And ex parte, the occupational order. So it was not bought in by the population. I remember one of my first domestic violence cases, a terrible case of domestic violence. This woman was brutalized from head to toe, physical, years of abuse, years of scars. We had an in-camera hearing. The magistrate stripped her. And you had scars that would have been there since I was a toddler. So you're talking about decades and decades of abuse. We had a full-blown hearing, and the magistrate made the order, full occupational order. And this man was a religious leader in his community. And he was this big macho man. First of all, to get him to go to court was a big issue. How dare his wife take him to court? Because the entire community was looking on. So in his head, he lost a lot of stature and status. And when the order was eventually made against him and he couldn't go home, he hung himself. He killed himself. Rather than comply with the order and in his head suffer the indignity of being put out of his own house, he killed himself. That is the mentality of a population in 1996-97 that you were expecting to apply this law. So it took a long time before the law got, not operationalized, but began to be used in the way contemplated and anticipated. And it solved its purpose. I think it served its purpose. But obviously not, it didn't achieve the high objectives that it was intended to achieve. Violence continued. We had to simplify the procedures, and ours is in the magistrates' court. You couldn't go to the high court, so all the processes were in the magistrates' court. And after many decades, we were able to identify loopholes, strategic, systematic deficiencies, and there were many. For example, the orders in our Domestic Violence Act were purely civil. They were not of a criminal nature. So there was one case where an occupational order was made, and the man went home with the order in one hand and a cutlass in the other hand and chopped the woman to death. And that's a real case. It happened not in my constituency. So you had that. Then you have the problem that I'm sure every one of the jurisdictions would face. The police and their reluctance to act, to get involved in what they would consider to be a highly personal domestic dispute. And all the safeguards that they would construct not to get involved. They don't have a warrant, they can't go into the premises, it's private property, a criminal offense is not being committed. All manner of excuses used to be conjured up not to get involved. And then, of course, you have the woman, or the victim, invariably is a woman, who goes back and begs to give the man a chance. Just after the violence, and then the man comes home back in the same house, and the empirical data is there to show you that the violence intensifies. And then the police becomes 10 times more reluctant on the next occasion. Because the police is saying, I warned you, I told you, let me don't arrest this man. You insist that I do, and now you're here to beg. And that goes up the police structure right through. So there is now almost a policy, or there was almost a policy position of the police. Their initial reluctance is now affirmed, and it becomes a part of their approach to domestic violence. You have also cases where in our old law where you have tenancy issues. So you get an order against the man, but he pays the rent. So he doesn't go in the house. You stop him from going in the house. The landlord is not paid. You have serious repercussions now. The landlord wants to get the victim out. So I can go through a whole menu of issues that we confronted in the old legislation. That in our new Family Violence Act, I knew I ran out of time, that's why I don't like to speak on these. I never get enough time. So in our Family Violence Act, we tried to address all these issues that we would have unearthed over the past 20, 30 years of that previous legislation being enforced. So we expanded the definition of family. And if you look at our bill, our legislation is a very wide definition of family, including children and children who are treated as children of the family, and so on. We increased the category of persons who can apply, And a stranger can now make an application to the court. So any community leader, religious leader, any person who witnesses domestic violence over a period can make an application to the court, but with leave of the court. We have expanded the definition of what is domestic violence. We have specifically empowered the police to do a number of things without a warrant. You spoke about none of the legislation has mandatory obligations. Ours do. It mandates the police to take actions, arrest, detain, ensure that the victim is safe, and also to document the procedures in the station. Every police station in Guyana has a domestic violence unit. We have specially trained officers. We have a domestic violence desk. We have domestic violence dedicated vehicles to supplement. And then my sister, cabinet colleague, Dr. Vindhya Prasad, will speak about the added institutions that we have created to support the legislation. Like the Health and Justice Center, we have centers where we provide counseling, accommodation, legal advice, medical assistance, police there. So you have an entire unit to help the victim. Then we created civil causes of action in our legislation. We created criminal offenses too. So if you breach a domestic violence order, you commit an offense and you can go to jail. Under the previous dispensation, you had to be charged for one of the ordinary criminal law offenses, assault causing actual bodily harm, wounding, etc. Now you have criminal offenses created in this legislation. Then, of course, as I said, you can get compensation for damage to property, damage to trespass to person, and so on. We addressed the issue that I spoke about, the tenancy. And we put in there that though the respondent is excluded by a court order due to domestic violence from the tenanted premises, the demised premises, he still obtains the obligation. He holds the obligation to pay the rent, etc. And then we have the question of bail, and we have listed a whole host of factors that a magistrate must take into account, including the possibility of an engagement or an interaction or a connection between the abuser or the alleged abuser and the victim, and children and so on involved. Very detailed. So we have a comprehensive piece of legislation that we are working with. We have a Sexual Violence Act also that criminalizes marital rape. So that issue is not covered here in our legislation, but it's covered in our Sexual Violence Act, and that is also under review. So we have a fairly, I think, a modern, comprehensive statutory framework, but of course we are reviewing it again. It was only passed last year, so I am yet to get empirical data to see how it has performed, but no doubt we have a law revision, a law reform commission that I ensure keep these types of legislation under constant review. So I'll stop there for the time being.
Thank you very much, Attorney General. You started off your presentation looking at root causes, and you said in the Caribbean, I think you said in the Caribbean, people cling to violence, and you gave the example of death penalty. But I think we also cling to this idea of corporal punishment. We often say, I took licks, but look at me, I turned out all right. And I always think to myself, did you really? But this takes me to one of the questions which have come on that wonderful WOVA platform. By the way, congrats to the organizers on that platform. I've never seen that, and I quite like it. But one of the questions on that platform addresses the question there. Attorney General, does your legislation consider the nexus between corporal punishment and domestic violence? Is there, do we still have a latitude in our laws for parents to discipline in the way that they think is appropriate? How do we address child protection? Because we also know that children who experience corporal punishment and children who witness domestic violence in their home are also more likely to be perpetrators and also to be victims because violence becomes normalized in their lives. So Attorney General, what do you say about corporal punishment and children now and in the future? I'm putting you on the spot. Attorney General, I also understand you're not running again.
If you allow me, I will give the preamble. When I moved to Barbados as an 11-year-old going into high school, I had to go do an interview because I was coming into second term. I was moving from Antigua to Barbados. And I went to the principal's office to interview with the principal. And when I walked in the office, I can see it in my head right now, I looked to my right and I saw a cabinet with the glass windows. In the cabinet were different types of sticks. So during my interview, I asked the principal, I said, Principal, nice to meet you and so forth. What is that cabinet of sticks? He said, young man, if you get in trouble, you come to the principal's office, you bend over the chair, and before you do that, you can choose a stick with which I will beat you. And that is the culture that we have in the Caribbean. That is a British colonial relic. I don't even think you can do that anymore in the British schools, but we've kept it. And that is just a preamble for when A.G. Marshall says if he's going to ensure that corporal punishment is included in domestic violence legislation in Barbados.
Thanks, Garth. When we look at our 1982 legislation, it identified domestic violence as a species of criminal activity. And therefore, it could never have been in our contemplation that corporal punishment could have been included as domestic violence, because corporal punishment simply is not treated as criminal activity within the context of our 1982 Act. Our 2016 Act doesn't open the door, in my view, either, but our 2016 Act defines, our 2016 Amendment Act defines domestic violence as the willful infliction or threat of infliction of harm by one person in a domestic relationship upon another person in that relationship, and includes child abuse, emotional abuse, financial abuse, physical abuse, and sexual abuse. So we've now added another word, the concept of abuse. And I will speak to you frankly as a Caribbean man, as a Caribbean parent. I don't think that while I was I don't want to say victim, I was the subject of many acts of corporal punishment as a child, and I turned out all right too. But I think that it is difficult to treat corporal punishment and abuse as being two fungible concepts. It is as simple as that. I think abuse has a very different connotation to the flogging of a child for breaching some rule in the household or breaching some rule at school. One, I think, is and I'm not going to try to define them, but I think that when we look at it from all that we know, it'll be difficult to say that flogging a child as a parental act or as an act by someone in loco parentis, a teacher in school or something like that, could be seen as being an act of abuse. Abuse would suggest a very different degree. And therefore, I do not think that our legislation, either it's an original form or in its amended form, even contemplated, and I speak as having been a parliamentarian in 2016 when the amendment was made, I don't think we ever contemplated that flogging a child would constitute an offense within the Domestic Violence Act.
I tend to agree with Dale and still disagree with him. So that may not have been the intent. And when they passed that in 2016, they didn't have in mind corporal punishment. But if you apply the definition as it exists, and it would be applicable. It would be applicable. And a court, I don't know, how do you tell the court that that was not your intention when the language is there? Beating of a child is a form of, it's called by the definition. So it may be an indirect positive in the sense that though you didn't contemplate it, we are moving in that direction now. In Guyana, I think we have corporal punishment in our statute books. And of course, we're not enforcing it in schools.
Yes.
And there is some degree of opposition from the population themselves. And that's the problem we have in the Caribbean.
Yes.
The same problem we have with the death penalty. The leaders are in a particular place on that issue, but their constituency is in a different place. And that same position obtains in relation to corporal punishment. Unlike Dale, I myself was the recipient
Yes.
of corporal punishment, both by teachers and my parents. So. And as I said, as you said, it came out good.
But I would say that we could all come out better. As someone who took licks myself as a child, yes. I think that I guess the question around corporal punishment is to be separate from the question around how do you discipline children appropriately. And I don't want to get off on it, but to say that we know that boys too are beaten more than girls in the Caribbean in schools, because you had that experience in school with the canes and the sticks, the rods of correction, as they say, and in the home. But we don't tend to make the connection between that experience and also the vulnerability of boys to perpetrate crime and violence later on. Of course, spanking in the home there's not a direct correlation between that, because you can have a home where there is that going on, but a lot of love and support. But you also have homes where that's the only thing going on and no love and support. So we have to be thinking, I think, and that's maybe your question, Attorney General Wilkin, that we need data. We need to understand not only the root causes of domestic violence, we need to understand the triggers. We need to understand who is more at risk of using violence and what is their background. And in that regard, then I think what I'm hearing you say, apart from understanding better the root and the root causes and the consequences of that, but we also need to be understanding better how the legislation is functioning. And I do want to say, Attorney General Wilkin, before I turn back to you for your last words, that the legislation, the model legislation in the OECS came out of an assessment, a quantitative and qualitative assessment of the domestic violence laws in the early 2000s in the 7 or 8 OECS countries, and including Turks and Caicos, but the Attorney General is not there. So it was informed by data. And I do want to say that we need another round of studies on how the acts are being implemented. But I think you want to say something.
Yeah, just something quickly. I was looking at our definition in our act. It says domestic violence means any controlling or abusive behavior that harms the health, safety, or well-being of any child. Yes. Now, if this matter were to go to the Privy Council, in the case of St. Kitts and Nevis, or to CCJ in the case of my colleagues up here, it would be interesting to see what that debate would be on the interpretation of well-being. Because certainly in the domestic context, a parent beats a child for their future well-being. And do you look at the... Yes, so the question is...
5 lashes were supposed to be your well-being, but you get 10. Yeah.
Exactly. So the question will come down to the interpretation, and it will be part of the cultural analysis of the country. The law lords can't do that in the Privy Council. They don't know what happens down here.
Well, that's why you should join the CCJ?
Well, I want to, but that's soon. But yes, but it'll be interesting to see how that debate matures. Yes. I am of the view that I agree. If it's 10 lashes 3 times a week, I think that can amount to abuse. Mm-hmm. But I can also see the situation...
Not welfare.
And not welfare, beyond welfare.
Not in the best interest of the child.
Yes, but if you smack your child on the wrist, twice a week, and they might get a black and blue, the question will be, if the order is granted, if that order is properly granted under the legislation. So it's a debate we can have in the Caribbean.
So we had our last words, and I would like to give each one of the Attorney General a minute.
So in my minute, I've reflected on what my colleagues have said. And Garth, you did say that your police department has asked for specific offenses. As AG, if my police department asked for that, I'd probably say no. I don't think that the domestic violence legislation was intended to create criminal offenses. It was always intended to operate in the civil sphere, which is the justification for easy access. I'm glad that you've moved yours from the High Court now to the magistracy. I think you could remove the 250 because our applications, yeah, you can remove that because our applications don't require the payment of any fee at all. But I think that the criminal arena, while there's obviously an opportunity for intersection, I have a feeling that the crafters of our legislation wanted to make sure that there was maximum protection of individuals, but mindful, and I think we have to accept this, mindful that there is some kind of a family unit that may be worthy of preservation. And if your first response is always going to be, and I'm very sympathetic with the police, and you mentioned it just now, where the lady will come and beg back. And in modern times, the men are begging too. So don't let's think that is one side. I think that, and certainly in our debates in Parliament, we did bear in mind, we did take into account that there's a reason why the word domestic is there. There's a family arrangement that may be salvageable, and therefore you don't want to create offenses under this legislation. And we already have numerous offenses to deal with sexual assault. We have it to deal with offense against the person. If the matter is grave enough to require that, then we have an entire range of offenses with which that person can be charged, and the police will do that as and when required. But I don't think we need to create another set of offenses. And in fact, a court in sentencing may well view the domestic relationship as an aggravating factor. So I don't think that we need to have specific legislation creating offenses under this legislation.
I'm sure you will get some response from the audience, but we do have to end the session. But I would like to give Attorney General you your last word.
So let me just clarify something that Dale said. Well, clarify what I said in relation to what Dale said. In Guyana, our new legislation doesn't create, it doesn't create new criminal offenses. It makes a breach of one of the orders an offense that carries criminal sanctions. And that we found necessary based upon the empirical data because the orders were being breached with impunity, and I gave you the most extreme of examples. So we felt that we had to put something more to that piece of paper. Yes. And of course, we vested it in the magistrate's discretion to make the orders when they are appropriate. And so I think we are moving in the right direction. We have to have more dedicated sessions of this nature, as I said. To tackle this issue successfully, we have to, it requires far more than legislation. But I think that we have done well legislatively, and we have, as a region, we have subjected our legislation to critical reviews, and we are amending them to meet the exigencies of our individual societies. So we put in mechanisms that we found were required in Guyana.
Yes.
Other countries are free to amend theirs to meet their situation. But what is important is that governments and the countries are alive to the importance of constant review, and the fact that we are meeting here is a significant recognition that this is a matter of utmost importance, and we have to continue to look at it from this perspective.
Thank you, Attorney General. Thank you at all Attorneys General, Attorney General Marshall, Wilkin, Nandlall, for this this session. I think you raised all very important issues, some of them a bit contentious and controversial in the room, but that's why we have the rest of the today and tomorrow to work through so that we move forward to recommendations forward. Already you've given us some ideas, the data, the review of the implementation of this legislation is important, but then also the expansion of the prevention programming, raising awareness all in schools and families and in communities. So thank you very much, Attorneys General, and can we tell them thank you?